Northlands Media PR and Marketing Limited presents the Global IP Magazine Issue 24. GIP Magazine 24, front cover text. Consumers want trust, not URLs, trademarks as the new digital identity. Robotics Patent Landscape 2025, Global Trends, Emerging Technologies, and AI-Driven Insights. Recent developments in copyright jurisprudence in Sri Lanka. A technical IP playbook for generative AI adoption. Plus much more. Main front cover heading. Reimagining IP services in the AI era, a human-AI collaborative future. Heidi M. Kawand, founder and CEO at AIP Genius, Bahrain. Front cover strip advertisement. Pat World. Patent intelligence platform and research services. www.patworld.com. Mail at patworld.com, telephone, +44 01633 816 601.
Page 2. Inside front cover advertisement. The Women's IP World 2026. Celebrating the work and achievements of women in IP lore, and innovation globally. Join the 7th annual edition of the Women's IP World Annual. Your story has the power to inspire. We invite you to join the Women's IP World Annual 2026 and be part of a global community of women who are shaping the future of IP. Profiles, accolades, experience, articles, ranking, achievements. Share your journey, connect with peers, and let your voice be heard. Contact us to join now. Visit website www.womensipworld.com. Call +44 0203 818 0457. Email us at info@womensipworld.com.
Page 3. Editor's Note. Dear readers, Happy New Year, and welcome to the first 2026 edition of the Global IP Magazine. We begin the year with exciting news. From this issue forward, the publication formerly known as the Global IP Matrix Magazine officially transitions to the Global IP Magazine. This new title reflects both our growth and our ongoing commitment to serving an international readership with clarity, depth, and authority across every dimension of intellectual property. Since launching in 2018, the publication has become a trusted voice within the global IP community, recognized by leading firms, in-house counsel, innovators, and service providers, consistently ranked first on Google for Intellectual Property magazine. Today, our rebrand signals the next step in our evolution, a more focused and unified identity with an expanded editorial mission to capture the full spectrum of IP insight, innovation, and industry direction. In this issue, we are pleased to present a powerful collection of articles that reflect the pace and complexity of our field. Our cover feature this issue, written by Heidi M. Kawand, founder and CEO at AIP Genius, explores the future of human-AI collaboration in IP services, demonstrating how technology can enhance analytical capabilities while strengthening, rather than replacing, human judgment and strategy. Eugenio J. Torres Oyola and Carlarin Encarnacion Pack of Ferraiwoli LLC present a topical discussion on the legal realities of dupe culture. Their article examines the commercial and legal tensions arising from lookalike products and trade dress imitation, offering insight into how brands can safeguard identity and value in an increasingly trend-driven digital market. Turning to copyright, Anomi Wanigasekara and Sabira Sharif of Julius and Creasy analyze a recent Supreme Court ruling from Sri Lanka involving the works of Clarence Wijewardene. Their article examines how the judgment clarified economic and moral rights, infringement, and the remedies available. It offers concise, valuable insight into the future direction of copyright jurisprudence in the region. These articles sit alongside many more insightful contributions from IP practitioners and industry leaders around the world, covering trademarks, patents, enforcement, commercial strategy, and innovation. We are grateful to our authors for their expertise and to you, our readers, for being part of this ever-growing global IP community. As we look ahead, may the conversations sparked by this issue and the knowledge shared within it inspire innovation, collaboration, and progress across the field. The management team. Northons Media PR and Marketing Limited. Published by Northons Media PR and Marketing Limited. Carlos Northon. CEO and founder, Northons Media PR and Marketing Limited, publisher of the global IP magazine, the Women's IP World and the Caribbean IP Annual. Carlos at northonsprmarketing.com. Dhruva Dakani. Director of Creative Design and Global Marketing for the Global IP Magazine, the Women's IP World and the Caribbean IP Annual. Dhruva at northonsprmarketing.com. Hitanshi Gohil. Junior Graphic Designer and Researcher for the Global IP Magazine, the Women's IP World and the Caribbean IP Annual. Hitanshi at northonsprmarketing.com. Bhumika Goswami. Sales Account Manager for the Global IP Magazine, the Women's IP World and the Caribbean IP Annual. Bhumika at northonsprmarketing.com. Zafira Hudani. Reporter at for Northons Media PR and Marketing Limited for the Global IP Magazine, the Women's IP World and the Caribbean IP Annual. Zafira at northonsprmarketing.com. Craig Barber. Head of Design for the Global IP Magazine, the Women's IP World and the Caribbean IP Annual. Info at northonsprmarketing.com. Disclaimer: all images in the articles are provided by the authors, unsplash.com, pixabay.com, pexels.com, canva.com, freepik.com and vecteezy.com. Page 4. Editorial Board of Directors. Malden Vukma, Vukma Attorneys, Croatia. Keisha Fleming Lake, Managing Partner at Cerveri Monsuarez, Anguilla. Laura Collada, Managing Partner, Dumont, Mexico. Max Montero, Partner, Johansson and Langlois, Chile. Ray Zhao, Senior Partner at Unitlan Attorneys at Law, China. Sarah Norka Anku, Managing Partner, S.N., Anku IP Law Firm, Ghana. Page 5. Contents page. Page 09. The Legal Side of Dupe Culture. Written by Eugenio J. Torres Oyola, Managing Member, and Carlarin Encarnacion Pac, Associate Attorney, at Ferraiwoli LLC, Puerto Rico. Page 11. Trademark Protection in a Borderless Digital Economy, Comparative Perspectives and Recent Trends Across the Caribbean and Beyond. Written by Natalie Glitzenhorn-Augustine, Sole Practitioner at Glitzlaw, St. Lucia. Page 15. Consumers want trust, not URLs, trademarks as the new digital identity. Written by Michelle S. Katz, Founding Partner, and co-authored by Noah Siskind, Associate at Advitum IP LLC, USA. Page 17. No trademark pirate can avoid cannon fire. Written by Vladimir Biryulin, Partner at Gorodisky and Partners, Russia. Page 21. Tanzanian Court of Appeal decision nullifying Aripo trademark protection designating Tanzania. Written by Jihad Ali E. Hassan, Chief Executive Officer, CEO, and co-authored by Mohine Fatah, IP Senior Director at JAH Intellectual Property, LLC, Tanzania. Page 23. A Technical IP Playbook for Generative AI Adoption. Written by Dr. Shweta Singh, Founder and CEO at Ennoble IP, India. Page 27. Reimagining IP Services in the AI Era, a Human-AI Collaborative Future. Written by Heidi M. Kawand, Founder and CEO at AIP Genius, Bahrain. Page 29. All Talk, No Consent, AI Voice Cloning and IP. Written by Zafira Hudani, reporter at Northons Media PR and Marketing Limited. United Kingdom. Page 31. Robotics Patent Landscape 2025, Global Trends, Emerging Technologies, and AI-Driven Insights. Written by Claire Gibson, Senior Patent Analyst, with additional analytical contributions from Geraint James, Senior IP Manager, at Patworld, United Kingdom. Page 37. Recent Developments in Copyright Jurisprudence in Sri Lanka. Written by Anomi Wanigasekara, Senior Partner, and Sabira Sharif, Senior Associate at Julius & Creasy, Sri Lanka. Page 39. From Fragmentation to Foresight, Why Data is the Missing Foundation of Global IP Quality. Written by Kerry Levitt, Strategic Advisor at Azami Global, USA. Page 45. From Admin to Asset, How IP Teams and Law Firms Can Transform Operations Through Data, AI, Spend Management, and Strategic Alignment. Written by Nadine Stuttle, Founder and CEO, IP Technology, AI, Operations and Transformation Advisor at PSS Solutions, Switzerland. Page 47. Protecting Creativity in the Digital Age, A Conversation with Attorney Justin M. Jacobson. Interview by Zafira Hudani, reporter at Northlands Media PR and Marketing Limited. United Kingdom.
Page 6. Advertisement. Advert 1. HK Acharya & Company, India. Advocates, patent and trademarks attorneys. Elevate your innovation. Protect your trajectory. Our services: patent design, IP litigation, trademarks, licensing, IP valuation, copyrights, and many more. Contact details: HK Avenue 19, Svastik Society, Navrangpura, Ahmedabad 380009, India. Telephone +9 17926 425 fax +9 17926 42526 and 25263. info@hkindia.com. Website: hkindia.com. Advert 2. PLE, Patent Litigation Europe. 19 to 21 January, Amsterdam. 3-day summit, 130 plus speakers, 850 plus attendees, 45% in-house counsel. Advert 3. United Trademark and Patent Service. Intellectual property attorneys. Your reliable partners for intellectual property matters in Pakistan, South Asia, Arabian Gulf, Middle East, and Africa. Trademark, patent, design, copyright, domain name registration, litigation, and enforcement law. Pakistan Office. 85 The Mall Road, Lahore 54000, Pakistan. Adjacent Rado Kronos / Hang 10 Mall Plaza Building. Telephone +9 242 362 855 88 90, +9 242 362 855 81 84. Fax +9 242 362 855 85, 362 855 86, 362 855 87. Email: unitedtrademark@unitedtm.com. Websites: www.utmps.com and www.unitedip.com.
Page 7. Contributors. The Global IP Magazine, Issue 24. Michelle S. Katz, Founding Partner at Advitum IP LLC, USA. Dr. Shweta Singh, Founder and CEO at Ennoble IP, India. Vladimir Birulin, Partner at Gorodisky and Partners, Russia. Claire Gibson, Senior Patent Analyst at Patworld, UK. Geraint James, Senior IP Manager at Patworld, UK. Justin M. Jacobson, Founder at Justin M. Jacobson Law Office, USA. Heidi M. Kawand, Founder and CEO at AIP Genius, Bahrain. Kerry Levitt, Strategic Advisor at Azami Global, USA. Sabira Sharif, Senior Associate at Julius & Creasy, Sri Lanka. Jihad Ali E. Hassan, CEO at JAH Intellectual Property, LLC, Qatar. Noah Siskind, Associate at Advitum IP LLC, USA. Mohine Fatah, IP Senior Director at JAH Intellectual Property, LLC, Tanzania. Zafira Hudani, Reporter at Northlands Media PR and Marketing Limited, UK. Natalie Glitzenhorn-Augustine, Sole Practitioner at Glitzlaw, St. Lucia. Eugenio J. Torres-Oyola, Managing Member at Ferraiwoli LLC, Puerto Rico. Anomi Wanigasekara, Senior Partner at Julius & Creasy, Sri Lanka. Carlarin Encarnacion Pak, Associate Attorney at Ferraiwoli LLC, Puerto Rico. Nadine Stuttle, Founder and CEO, IP Technology, AI, Operations and Transformation Advisor at PSS Solutions, Switzerland. Contribute to the Global IP Magazine. For those keen on contributing their expertise within the realm of intellectual property, IP, to a global audience, we cordially invite you to reach out to us at gipmagazine@northlandsprmarketing.com or via telephone at +44 0 2038130457. We eagerly anticipate the opportunity to collaborate and disseminate valuable insights within the IP industry.
Page 8. Advertisement. 2026 AIPL Spring Meeting. Mark your calendar. Registration opens January 31st, 2026. The 2026 Spring Meeting will be held May 13th to 15th at the Fairmont, San Francisco.
Page 9. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: The Legal Side of Dupe Culture. Subhead: Eugenio J. Torres-Oyola, Managing Member, and Carlarin Encarnacion Pac, Associate Attorney, at Ferriwoli LLC, Puerto Rico, explore how trademark law, brand strategy, and IP rights collide with the rise of dupe products. Picture this. You are casually scrolling through TikTok when an influencer starts raving about a luxury handbag you have been eyeing for months. Normally, the price tag alone would make you hesitate, whether because it is simply out of budget or because you are not interested in spending a small fortune on a single item. But this time, something is different. The handbag they are promoting costs a third of the price, looks identical, and is proudly marketed as a dupe. For newer generations of consumers, purchasing affordable versions of expensive handbags, apparel, jewelry, and other products is no longer something to hide. It has become content to showcase on social media. Platforms like TikTok and Instagram have played a central role in the rise of dupe culture, where users enthusiastically promote affordable lookalikes of high-fashion items. A dupe, short for duplicate, is commonly understood as a lower-cost product that imitates the appearance or overall design of a luxury item. The brands that create these products often operate in a legal gray zone. They recreate the look and appeal of a high-end product while intentionally avoiding the direct copying of words, logos, or other protectable brand identifiers. This careful line drawing allows dupes to flourish in the marketplace, even as they raise significant questions about consumer perception, brand equity, and the limits of trademark protection. Trademark basics. To understand where dupes stand legally, it is essential to look at the U.S. trademark law and the rights afforded under the Lanham Act. In the U.S., trademarks are registered through the United States Patent and Trademark Office, USPTO, which protects words, logos, symbols, and designs that identify the source of goods or services. A federal registration grants nationwide rights and several important legal advantages. These include public notice of the trademark registration, a legal presumption of ownership, the exclusive rights to use the trademark in connection with the listed goods or services, the ability to use the symbol, and the option to record your registration with U.S. Customs and Border Protection, CBP, to help prevent the importation of goods bearing infringing marks. Federal registration also bars others from registering marks that look, sound, or convey a meaning similar to an existing mark when used on related goods or services. At its core, trademark law is designed to prevent consumer confusion about the source of a product or service in the marketplace. Where it gets complicated. Protecting fashion under trademark law is not always straightforward. While specific words, logos, or designs may be protectable, other elements of a fashion item are far more difficult to safeguard. Some features require a heightened standard of proof, while others are simply not protectable at all. For instance, to protect a trade dress or overall look and feel of a product, a brand must prove secondary meaning, showing that consumers recognize the design as coming from one source. This requirement can be particularly challenging for emerging designers who may not have widespread recognition in the marketplace. In contrast, more generic elements, such as basic clothing shapes, ornamental uses, functional elements, or common design patterns, are generally considered non-protectable and often remain outside the scope of trademark protection. This is precisely the gray area in which the dupe industry operates. As long as their products avoid copying protectable elements such as trademarks, design patents, or copyrighted features, they are not considered illegal copies in a strict legal sense. Dupe makers often argue that their products are not intended to deceive consumers into believing they are purchasing the real item, but rather to offer a lower-cost alternative inspired by the original. This is a position strongly contested by luxury brands, particularly as dupes may dilute a brand's reputation when associated with lower-quality versions. What's next? Despite all, brands can still push back. Register the brand's essentials. The brand name and logo should be registered as a trademark. If the mark is not yet in use, this can be done under Section 1(b), so long as the brand has a bona fide intent to use it in commerce within the next 3 years. Beyond traditional word marks and logos, the brand should also protect its distinctive elements. These may include patterns, color combinations, design elements, or the specific placement of certain features that serve as source identifiers. Get creative. For example, the brand Lululemon recently secured a registration for Lululemon Dupe, a bold strategy that effectively turns dupe culture into a brand asset. The registration was secured under Section 44(e), meaning it is based on ownership of a foreign registration, but it illustrates how brands are trying to reclaim the narrative through both legal protection and marketing. Of course, there are limitations. Registration is only worthwhile if the cost aligns with the value of the protection and if the brand is prepared to enforce its rights against infringers. Enforcement can be costly, and litigation is often out of reach for emerging designers who cannot afford to engage in lengthy court battles. Given how quickly fashion trends move, financial and time investment may not always be proportionate to the commercial value of a single product or design, especially in an industry where trends evolve faster than cases can be resolved. The bottom line. Threading the needle between inspiration and imitation perfectly captures the era of fast-moving trends and the rise of dupe culture. To remain competitive, brands must pair creative vision with a well-defined legal strategy. Trademark protection is a central component of that strategy, offering exclusivity, enforceability, and a clear signal to the market regarding the ownership of brand identifiers. Yet trademarks constitute only one layer within a broader IP framework. Forward-thinking brands should build a stronger IP shield, complementing trademark rights with copyright and design patent protection wherever applicable. As dupe culture continues to influence consumer behavior and reshape market dynamics, adopting a multidimensional IP strategy becomes essential to safeguarding brand identity and protecting long-term commercial value. Page 11. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Trademark Protection in a Borderless Digital Economy, Comparative Perspectives and Recent Trends Across the Caribbean and Beyond. Subhead: Natalie Glitzenhahn-Augustine, sole practitioner at Glitzlaw, St. Lucia, explores how global trademark trends, landmark court decisions, and rising regional filings are reshaping brand protection strategies for Caribbean businesses in the digital age. Recent data from the World Intellectual Property Organization, WIPO, shows that, after a dip, global trademark filings and registrations are recovering, a fact with significance for Caribbean brands looking outward. In terms of geographic distribution, Asia continues to dominate global filing, with about 2/3 of total applications, but the Latin America and Caribbean, LAC, region still accounts for a modest share. As of 2023, LAC offices had roughly 7.1% of global trademark filing activity. Thus, while the Caribbean is a smaller piece of the global IP filing pie, global renewal of trademark activity, and the fact that registrations continue to accumulate underscore both risk, increased competition, possibility of infringement, and opportunity, expanding reach. Globalization for Caribbean brands. Specific to the Caribbean region, there are signs of growing awareness and use of trademark registration. The Cayman Islands Intellectual Property Office, CIPO, serving as a leading offshore and financial services hub, reported 329 trademark registration applications between January and June 2024 alone. That number represents more than half of all registrations in 2023. By December 2022, CIPO had approved 568 registrations, surpassing prior records. This data suggests increasing engagement with formal IP protection in jurisdictions that, like many Caribbean economies, feature international business, trade, and cross-border commerce. This is relevant for regional brands and investors alike. Many Caribbean entrepreneurs now rely on e-commerce platforms, which bring exposure, but also increase the risk of counterfeiters, unauthorized resellers, and infringers often operating within these ecosystems. Getting platforms to act. take down infringing listings, or enforcing rights through them requires legal sophistication. Moreover, the cross-border nature of platform sales means that infringing actors might operate under jurisdictions with weak IP enforcement, limiting the effectiveness of traditional litigation or customs enforcement. The digital economy underscores the need for proactive monitoring and engagement with platforms, alongside robust trademark registration. To understand how trademark law is evolving globally, and what that might mean for Caribbean stakeholders, it helps to look at recent high-profile cases in other regions. Two such landmark decisions stand out. 1. Skykick v. Sky, broad filings, bad faith, and limits on trademark stockpiling. On 13 November 2024, the UK Supreme Court delivered a landmark judgment finding that the Sky Group, Sky, had registered trademarks in bad faith by including overly broad categories of goods and services, many of which the company had no genuine intent to market. The court held that a registration can, and should, be invalidated or narrowed where the applicant lacked objective justification, commercial rationale or credible plan for using the mark in respect of certain classes at the time of filing. In practical terms, the ruling discourages monopoly-style behavior where a brand registers broadly simply to block others, without real intent to use across all classes. Lawyers have flagged this as a significant shift. Bad faith objections may become more common in future litigation. Caribbean brands, or foreign brands targeting the Caribbean market, should be wary of overbroad applications for trademarks, especially when specifying many classes, goods and services, beyond their actual business. Overfiling could expose registrations to challenges for bad faith. For regional businesses filing in Caribbean or offshore jurisdictions, this trend suggests the need for discipline and realism in trademark applications, and for challengers, a viable path to push back against aggressive registrations. 2. Dewberry Group v. Dewberry Engineers, limits on recovering profits from affiliate entities. In a 2025 ruling, the United States Supreme Court unanimously overturned a prior US $43 million award in a trademark infringement case, holding that a plaintiff may not recover profits from a defendant's affiliates unless those affiliates were themselves named in the lawsuit. The decision underscores limits on the recovery of monetary damages in large companies' corporate structures. Even if infringement is proven, profits from related but separate entities may not be disgorged, absent their inclusion in the action. For large multinational entities, including those with Caribbean operations, this decision reduces the potential deterrent effect of litigation when affiliates are left out. For brand owners, it highlights the importance of comprehensive pleadings, identifying all relevant affiliates, if they wish to recover profits. For smaller Caribbean businesses facing infringement from conglomerates, this may mean that even a favorable ruling provides limited financial remedy. Other notable developments: free speech and registrability. In the US, the Vidal v. Elster decision, June 2024, reaffirmed that a provision of the US trademark statute, restricting registration of marks using living persons' names without consent, does not violate the First Amendment. While not directly about digital commerce, such decisions influence global practice. Brands that use personal names or reference persons, public or private, must remain attentive to legal and constitutional constraints, especially when marketing across borders or within diaspora communities, as is often relevant for Caribbean audiences. Putting together the global data, recent case law, and regional IP filing snapshots yields several implications for the Caribbean. Trademark filings and registrations globally remain active, and are growing. For Caribbean brands expanding internationally, or domestic brands anticipating growth, this signals that proactive registration, both at home and abroad, remains a critical strategic move. Modern abuse of trademark law, overbroad filings, trademark stockpiling, misuse of trademark tools, is being curbed by courts, especially in jurisdictions with mature IP jurisprudence, e.g., the UK. For Caribbean applicants and registrants, this means apply carefully, credibly, and with a real business plan. Avoid spray-and-pray filings covering dozens of unrelated classes unless you truly intend to use them. Litigation remedies may be narrower than expected. As the Dewberry case shows, plaintiffs may not recover all profits when corporate affiliates are involved. For brands operating through complex corporate structures, including offshore, affiliate-heavy setups common among Caribbean-based firms and holding companies, ownership structure, and clarity matter. IP offices in the region are seeing increased use, signaling growing awareness. The example of SIPO shows that even smaller jurisdictions are ramping up registration activity, which may invite more competition, but also more opportunity for branding, reputation building, and legal protection. Cross-border reach, digital commerce, diaspora markets, online marketplaces makes global trademark strategy more important than ever, but so does sound, defensible application. As brands move online, attempt regional growth, or dip into global markets, the legal changes elsewhere will likely influence how Caribbean courts, registries, and enforcement agents view foreign and domestic trademark applications. Lessons and strategic recommendations for Caribbean stakeholders. Given the evolving global context, the following strategies make sense for Caribbean brand owners, entrepreneurs, and policymakers. Be realistic and focused on trademark applications. Register only for goods or services that reflect current or very plausible future business lines. Avoid overly broad filings that may trigger bad faith challenges. Even if the goal is expansion, registrations should reflect credible business planning. Build a multi-jurisdictional trademark strategy. Given the small share of global filing from LAC, but also growing global IP activity, Caribbean brands looking beyond local borders, diaspora, tourism markets, e-commerce, should consider registrations in key jurisdictions internationally or via systems such as the Madrid system when available appropriate. Maintain accurate corporate affiliate records and include all relevant entities when enforcing rights, to maximize recovery in case of infringement. As the Dewberry case shows, failure to name all entities may block profit disgorgement. Monitor global jurisprudence and consider its influence. Even if a case originates in Europe or the US, its reasoning, e.g., on good faith, intention to use in commerce, may influence global IP norms or be persuasive in other jurisdictions. Expand and support regional IP infrastructure and awareness. IP offices such as SIPO appear to be growing. Caribbean governments, business associations, and legal professionals should support capacity building, lawyers, examiners, public education, to ensure local businesses can leverage trademark protection effectively. One might wonder, why include cases from the UK or US in an article about Caribbean trademark protection? There are several reasons. Global legal reasoning tends to ripple out. Landmark decisions from mature IP jurisdictions, UK, US, often influence doctrine worldwide, especially in common law or Atlantic-oriented jurisdictions, many Caribbean countries. Courts in the Caribbean may not bind themselves to those rulings, but they often look to them for persuasive reasoning when handling new or digital-era disputes. Digital economy is borderless. A Caribbean brand may sell online to customers in the UK, the US, the EU, or elsewhere and require protection in those markets. When filing or enforcing trademarks abroad, the standards used there, e.g., for bad faith or intention to use, will matter. Offshore international business structures. Many Caribbean businesses, or investors targeting the region, operate via holding companies, affiliates, or multi-jurisdictional corporate structures. A ruling like Dewberry underscores the practical importance of naming the correct entities in litigation. Preventive value. By learning from how courts elsewhere are curbing systemic abuse, overbroad filings, trademark bullying, speculative registrations, Caribbean applicants can avoid adopting strategies that may later be criticized, whether abroad or at home. The Caribbean sits at a critical juncture in the evolution of trademark law. On the one hand, digital transformation and cross-border commerce are accelerating. On the other hand, the legacy of fragmented legal systems and uneven IP capacity still constrains many businesses. Yet, the momentum is growing. Legislative reforms in jurisdictions like Jamaica, the Bahamas, and Bermuda signal a willingness to modernize. Training initiatives, such as WIPO's 2025 course, are helping IP administrators understand digital use trademarks. And regional institutions, including the CCJ, could play a central role in harmonizing approaches, especially as cross-border disputes become more common. For Caribbean businesses, brand owners, and policymakers, the imperative is clear: adapt IP strategies to the borderless digital economy, or risk losing control of one of their most valuable intangible assets. In the years ahead, key success factors will include multi-jurisdictional registration, continuous monitoring, capacity building, and legal reform aligned with digital realities. With these in place, Caribbean enterprises can leverage trademark protection not just as a defensive tool, but as a strategic asset in global markets. Conclusion: a more nuanced, future-oriented view. Trademark protection in a borderless digital economy remains more critical than ever, but the landscape is shifting. The global rebound in filings and registrations confirms that businesses still see strong value in formal trademark protection. Yet courts in leading jurisdictions are imposing stricter discipline on how trademarks are applied for and used, especially in guarding against unjustified monopolization or stockpiling of rights. For the Caribbean, a region where many businesses are small or medium-sized, where corporate structures may involve offshore holdings or affiliates, and where digital commerce, e-commerce, export-oriented creative goods, diaspora sales, offers a route to growth, these developments carry real significance. A forward-looking trademark strategy for Caribbean enterprises should therefore combine careful, realistic registrations, multi-jurisdictional protection where relevant, sound corporate structuring, ongoing monitoring, domains, markets, online platforms, and awareness of global IP jurisprudence. If these pieces align, Caribbean brands can not only defend themselves against misuse or infringement but also proactively leverage their marks as strategic assets, enabling expansion, value creation, and global presence.
Page 14. Advertisement. INTA Annual Meeting. London, England, May 2nd to 6th, 2026. The world's premier intellectual property event is coming to London. Early bird registration opens December 8th. 2025. Scan the QR code for details.
Page 15. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Consumers want trust, not URLs. Trademarks as the new digital identity. Subhead: Michelle S. Katz, founding partner, and Noah Siskind, associate, of Advitum IP LLC, USA, examine the changing landscape from domain name centrality to trademark-backed e-commerce as consumers seek online trust. In the early 1990s, when the Internet first opened for commercial use, domain names became a coveted asset for any business. Businesses scrambled to secure catchy, memorable URLs that would serve as their online storefronts. A strong domain name was not just a technical requirement, but a marketing asset that could define a brand's success. With this knowledge becoming mainstream, opportunists began registering domains that matched famous brands, hoping to sell them back at a profit. This practice became known as cybersquatting. Companies fought cybersquatters to reclaim their digital names, triggering waves of lawsuits throughout the 1990s. To restore order, the Internet Corporation for Assigned Names and Numbers, ECAN, established the Uniform Domain Name Dispute Resolution Policy, UDRP, in 1999, giving trademark owners a clear path to recover their domain names. For years, protecting a URL was synonymous with protecting a brand. Fast forward 3 decades, and the way businesses reach consumers has changed dramatically. Consumers do not always begin their pursuit of a brand by typing a web address. Instead, they search within ecosystems like Amazon, TikTok Shop, Etsy, or Instagram, platforms where domain names are nearly invisible as they are buried beneath interfaces and algorithms. The site that once served as a brand's home base is now just one of many touchpoints in a massive online marketplace. In this new environment, consumers are not looking for clever domains from businesses. They are simply looking for trust. Trust that a product is authentic, safe, and reliable. For today's platforms, that trust comes not from a URL, but from a trademark. Major digital marketplaces have embraced this reality. They recognize domain registration is not the only proof of legitimacy, they view trademarks as the definitive marker of authenticity. Today, a trademark is not just a name, but a legal declaration that a business owns its identity and that its products meet a certain standard of quality. TikTok Shop's brand authorization process illustrates this shift. sellers must prove that they have the legal right to sell specific branded products by submitting a U.S. Patent and Trademark Office (USPTO) registration certificate or written authorization from the trademark owner. This system distinguishes between brand owners and authorized resellers, ensuring each list only what they are entitled to sell. By enforcing this process, TikTok helps eliminate counterfeits, reinforcing trust among consumers and brands. Amazon has gone even further with its brand registry, a program that protects both brands and shoppers. To enroll, sellers must hold an active registered trademark or a pending application through an accepted intellectual property office. Once approved, they gain access to automated tools that detect and remove counterfeit listings, reporting systems for IP violations, and enhanced content features that let businesses showcase their product. From this, when shoppers see that a brand is verified through the registry, they are more likely to believe the product is genuine. Sellers without trademark protection face steep disadvantages such as limited control over listings, exposure to imitators, and the constant risk of unauthorized resellers harming their reputation. The shift from investing in URLs to trademarks reflects a broader transformation in today's market. The Internet is no longer a collection of standalone websites and instead a network of platforms where brand reputation outweighs the ideal web address. Today's buyers discover products on Amazon, watch reviews on TikTok, and follow promotions on Instagram. A trademark provides continuity across these spaces. It acts as a digital ID, proving authenticity wherever a brand appears. For entrepreneurs and small businesses, securing a trademark is essential. It not only protects against counterfeiters but also unlocks tools and programs that boost visibility, credibility, and sales. A strong trademark strategy helps new businesses compete in crowded marketplaces and assures customers that what they are buying is authentic. The evolution from domains to trademarks marks the development of online commerce. The early Internet was about location. Whoever found the best web address had an advantage. Today, it is about reputation, and whoever can earn and keep consumer trust finds greater success. Even more so, a trademark accomplishes what a URL never could. It promises consumers that behind the platform interface stands a real, accountable business. In the modern digital economy, trust is the new currency, and trademarks are the seal that backs it. Building a credible, legally protected brand matters far more than owning a clever domain name. Consumers are no longer searching for URLs, they are searching for a trademark they can trust. Page 17. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: No trademark pirate can avoid cannon fire. Subhead: Vladimir Biryulin, partner at Gorodisky and Partners, Russia, documents the details of a case in which Canon defended its well-known trademarks in Russia against a local company's attempt to cancel and copy them. Canon, the familiar name of the Japanese optical, imaging, and industrial products company, came to Russia more than 25 years ago with its cameras and printing paraphernalia and became popular due to the quality of its products. From the outset, Russia became an important market for high-tech equipment, and Canon could cater to the needs of amateur and professional users. Building on its cautious marketing strategy in Finland through its subsidiary, Canon expanded into Russia and established a Canon Russia subsidiary. For many years, Canon supplied equipment to Russia with no questions asked. In the spring of 2022, Canon temporarily suspended its business in Russia because of the conflict in Ukraine, or because of the high volatility of the Russian ruble, as some media explained. By that time, Canon had a number of its trademarks registered in Russia. Namely, 28129, 58987, 314687, 320959, 375851, in Class 9. As is known, in Russia, after a 3-year period of non-use of a trademark, an interested person may cancel it. An interested person may be any person who has a lawful interest in the cancellation of the trademark. That person should have the intention to use the trademark not only for labeling goods for which the trademark is registered, but may also use it for similar goods. When some foreign companies left the Russian market, there were a number of attempts by interested persons to register trademarks similar to those belonging to the companies that had left the market. Stroyrizas Limited, a Russian company, filed a trademark application number 2023739712 in 2022 in Class 9, obviously planning to cancel the original trademarks in due time. 1 year later, the Patent Office issued a notification informing Streurizers that its applied designation is similar to Canon's trademarks. Streurizers, following its plan, initiated a non-use court action against Canon. In order to prove its interest as required by law, Streurizers submitted a preliminary supply contract for electronic locks labeled with Canon designation, an agreement of joint activities for developing a pilot sample, a task order, and other similar documents. Based on those documents, the plaintiff argued that they were indeed an interested person to cancel the trademarks in respect of mechanical locks, electronic and electrical locks, and eye viewers. Canon traversed the claim, arguing that the plaintiff had no real interest in the cancellation of the trademarks but was interested in registering a trademark identical to famous trademarks and imitating the name of the well-known company. They wanted to ride on the popularity of the Canon trademarks, confuse consumers, and obtain unfair advantages for promoting their goods on the market. The disputed trademarks became well known through long periods of use in general, as well as with respect to specific goods such as cameras, printers, scanners, and other goods. The court noted that the plaintiff had previously, January 2024, sent a proposal to Canon, asking it to abandon its trademarks, but the letter went unaddressed. Such a letter is a formal requirement of the law. The court agreed that there was indeed a preliminary contract for working out designs of locks, eye viewers, and other items carrying the designation Canon. The catch, however, is that the contract was concluded after the proposal to abandon the trademarks was sent, which means that the plaintiff had no interest in the trademarks before that proposal. When trying to cancel a trademark, the plaintiff must provide evidence showing that they do something in connection with the marketing of goods for which the disputed trademark is registered, i.e., electronics. Absence of interest is an independent basis for rejecting the cancellation claim. The court compared the applied designation Canon and the trademarks owned by Canon and found a high degree of similarity between them. The court took into account information provided by the Japanese company. Thus, according to a public survey, 96% of respondents are familiar with the trademark Canon, 66% of respondents said that this designation is used for cameras, accessories, and lenses, 37% for chargers, and so on. All associated goods are concatenated with the Japanese company. In so doing, people have known the name Canon for many years, and many of them bought and used the goods made by Canon. Besides, 53% of the respondents said that the designations Canon and Canon are different versions of the same name, and that they are owned by the same company, and that the products marked are manufactured by Canon or with its permission or license. The court concluded that the Japanese company is widely known in Russia, which may be explained by its presence in the Russian market for many years. Considering the arguments put forward by both sides, the court dismissed the Russian company's claim. It should be noted that there was another court case 1 year earlier. Streurizers applied to cancel another Canon trademark, number 90917 in Class 6, and was successful in cancelling Canon trademark for metal and non-metal cables, strongboxes, and wires. Inspired by the success, it attacked Canon again, hoping to divest it of all other trademarks, but failed. Bottom line, the plaintiff failed to cancel Canon's trademarks because it could not prove its interest. That does not mean that the trademarks are now safe. There are murky companies that attack trademarks, order manufacturing products elsewhere, and label them with the attacked trademarks. Some companies that left the Russian market refiled for their trademarks to refresh the 3-year period. However, the best way to preserve a trademark would be to sell a consignment or several consignments of goods, thus avoiding accusations of fictitious use, through an authorized agent in order to break the 3-year period, even if the company does not want to return to the market. This would not only save money for protecting trademark rights but also would bring some profit to the company.
Page 19. Advertisement. Gorodiski. Intellectual Property TMT. www.gorodiski.com. Page 20. Advertisement. Global Legal Forum. IP Track. Where intellectual property meets international excellence. Global Legal Forum 2026. 5th and the 6th of March. The Hague, Netherlands. Join 550-plus legal professionals from across the globe as we convene at the world-renowned legal capital for 2 days of unparalleled networking, knowledge exchange, and thought leadership. Featuring our intellectual property track. Explore the cutting edge of IP law with international experts discussing. Featured sessions on AI and IP protection. Cross-border enforcement. Patent prosecution. Brand protection. Registration open. www.globallegalforum.com.
Page 21. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Tanzanian Court of Appeal decision nullifying Aripo trademark protection designating Tanzania. Subhead: Jihad Ali E. Hassan, Chief Executive Officer, and Mohine Fatah, IP Senior Director, of JAH Intellectual Property, LLC, Tanzania, outline the implications of Tanzania's landmark ruling on Aripo trademarks and urgent national refiling strategy for brand owners. A seismic judicial determination delivered by the Court of Appeal of Tanzania on September 26, 2025, has created an immediate and severe regulatory crisis concerning IP protection within the jurisdiction. The decision, stemming from Civil Appeal No. 593 of 2022, specifically addressed the validity and enforceability of trademark registrations secured via the African Regional Intellectual Property Organization, ARIPO, under the Banjul Protocol on Marks. The critical finding is that Tanzania has not locally domesticated the Banjul Protocol, rendering any trademark right obtained solely through that regional filing system legally unenforceable within the country. This pivotal judgment has immediate and profound implications, fundamentally altering the strategic landscape for securing and enforcing brand rights in one of East Africa's largest and most commercially significant markets. The court established that while Tanzania is recorded by ARIPO as having acceded to the Banjul Protocol on Marks, the protocol was never formally incorporated into national statute. The court affirmed that, in the absence of this explicit parliamentary enactment, the Banjul Protocol has no legal force or effect within the Tanzanian territory. Consequently, any trademark registered through the regional ARIPO system and designating Tanzania does not, in fact, exist under Tanzanian law. This judgment serves as a robust affirmation of the territoriality principle of IP rights. Exclusive rights over a mark arise only upon domestic registration. Therefore, the respondent in the case, who relied on their ARIPO registration, failed in their claim because the registration was simply not recognized as a valid right under domestic law. This ruling provides crucial clarification that international instruments, regardless of their status at the diplomatic level, do not take effect domestically unless formally enacted through national legislation. In the wake of this appellate ruling, the ARIPO Secretariat issued an official circular, reference ARIPO_BP 2025-1, formally acknowledging the critical legal defect. The national authority, ARIPO, announced that Tanzania is now ineligible for designation under the Banjul Protocol until further notice. This administrative suspension is comprehensive and has two distinct effects that must be clearly understood by all stakeholders. First, it immediately halts the ability of new applicants to use the regional system ARIPO to secure rights in Tanzania, mandating the use of the national filing route. Second, and more critically, it officially confirms the compromised legal status of all existing ARIPO registrations that designated Tanzania. These marks are now rendered unenforceable and unable to form the basis of an infringement action, an opposition, or a commercial licensing agreement within the country. This situation has created a dangerous and immediate gap for brand owners, where marks they believed were duly protected regionally are, in fact, entirely vulnerable to local copying or exploitation. It is essential for practitioners to distinguish the impact of this ruling from other regional rights. The urgent fallout from this ruling requires brand owners and their legal counsel to conduct an immediate and thorough review of their IP portfolios in the ARIPO region. Any proprietor relying solely on their ARIPO designation in Tanzania essentially possesses no effective legal standing to enforce their mark against counterfeiters or infringers. For any client with existing ARIPO registrations designating Tanzania, the strategic directive is a rapid pivot to the national system. We strongly recommend that these clients proceed without delay to file new, parallel national trademark applications directly with the National Trademark Office. This is the only reliable method for establishing presently enforceable rights within the country. For all future filings, the national route is now the only certain and viable path to securing effective and enforceable trademark protection in Tanzania until the legal status of the Banjul Protocol is officially resolved through local legislative action. The judgment of the Tanzanian Court of Appeal serves as a powerful and indispensable reminder of the fundamental importance of the territorial principle in IP law. ARIPO has officially acknowledged the challenges, with the Director General, Bimania Twebes, assuring its valued users and stakeholders that Tanzania is committed to pursuing all available legal, administrative, and diplomatic avenues to expedite domestication of the protocol. While legislative efforts proceed, brand owners cannot afford to wait. The current situation demands a proactive and defensive strategy of national refiling and direct engagement with the Tanzanian Trademarks Office to secure the enforceable rights necessary to protect commercial investments and valuable brand assets in this vital African market. The immediate refiling effort is the only definitive action that can close the legal gap created by this landmark judicial decision. Page 23. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: A Technical IP Playbook for Generative AI Adoption. Subhead: Dr. Shweta Singh, founder and CEO of Ennoble IP, India, discusses inventorship, authorship, and model provenance for building enforceable IP around generative AI. Inventorship, authorship, and model provenance have become the central legal pressure points for any serious generative AI deployment strategy in 2025 to 26. For corporates, SMEs, and law firms, these issues now define which AI-enabled outputs can be owned, how they can be enforced, and what exposure exists across the full AI lifecycle from data ingestion to downstream commercialization. Generative artificial intelligence, Gen AI, has moved from experimental novelty to operational infrastructure across R&D, product design, branding, and content creation. As enterprises embed Gen AI into core workflows, traditional IP doctrines, particularly inventorship, authorship, and ownership, are under unprecedented strain. The central challenge is no longer whether AI can create, but whether organizations can prove human contribution, trace model provenance, and sustain enforceable IP rights in a multi-jurisdictional environment. This article provides a technical, practice-oriented playbook for corporates, SMEs, and law firms navigating AI-assisted innovation. It focuses on three interdependent pillars: inventorship, patents, authorship, copyright, and model provenance, data, models, and outputs. The analysis moves beyond theory to governance architecture, evidentiary standards, and operational controls required to make AI-generated or AI-assisted outputs legally defensible. Doctrinal fault lines, inventorship and authorship. Global patent and copyright regimes have converged on a common baseline: AI systems are tools, not inventors or authors, even as they increasingly drive the inventive and creative process. In patents, US and UK decisions rejecting AI as an inventor, combined with USPTO's 2024 and 2025 inventorship guidance, reinforce that only natural persons can be named, though AI assistance does not render inventions unpatentable. On the copyright side, the US Copyright Office's multi-part AI report and the 2025 DC Circuit decision in Thaler v. Perlmutter have crystallized a similar position. Human authorship is a non-negotiable requirement, and outputs created with little or no human creative input, such as fully automated responses to generic prompts, are not protectable. At the same time, those reports emphasize that works incorporating or derived from generative outputs can be protected where human creators select, arrange, curate, or substantially modify AI-generated material in ways that reflect their own intellectual creativity. From black box to evidentiary record, why provenance is now central. Across both regimes, a single practical theme emerges: rights turn on demonstrable human contribution, which in turn depends on being able to reconstruct how a model was trained and how a particular output was produced. Without a granular model and data provenance, applicants will struggle to establish human conception for patent purposes or to show sufficient human authorship to support copyright claims. Regulators and policymakers are increasingly linking provenance to broader risk governance, highlighting the IP, privacy, and contractual implications of training on scraped data and opaque third-party datasets. Reports from international bodies point to data scraping, unlicensed training corpora, and the removal of rights management information as key sources of liability, pushing enterprises toward traceable, licensed, or internally curated datasets for high-value use cases. Comparative landscape, where jurisdictions are actually diverging. Although the human-only inventorship and authorship requirement is broadly shared, jurisdictions diverge markedly on how they treat training and model use. In the US, fair use remains the primary analytical lens for assessing unlicensed training on copyrighted content, leaving considerable uncertainty but also more room for developer-friendly interpretations than in many other markets. In the EU and UK, text and data mining exceptions under the EU Copyright Directive and national legislation permit certain forms of AI training but allow rights holders to opt out through machine-readable reservations, creating a more granular but operationally complex framework. For multinational AI programs, this fragmentation means that a single global model trained on scraped data may be a tolerable risk in one jurisdiction but a high risk in another unless rights-cleared, tiered, or region-specific datasets and deployment patterns are adopted. Technical Playbook: Structuring Inventorship in AI-Assisted R&D. For corporates and SMEs using generative models in product development, the immediate challenge is to avoid both under- and over-claiming human contribution. Current USPTO guidance, as analyzed in recent scholarship and agency materials, focuses on traditional conception standards applied to AI-assisted activity. An individual is an inventor only if they make a significant contribution to each claimed invention element. Practically, this requires mapping each claim element to specific human technical decisions, such as problem framing, selection of model architectures or prompting strategies, evaluation metrics, and acceptance or rejection of AI-generated candidate solutions. Treating model outputs as hypotheses or design variants that inventors critically assess, refine, and integrate, with contemporaneous records showing why certain outputs were adopted and how they were transformed into the final inventive concept. R&D and IP teams should institutionalize structured invention disclosure forms that explicitly identify AI tools used, the stages at which they were deployed, and the human cognitive contributions that transformed raw outputs into claimable subject matter. In contested cases, these artifacts will be decisive in demonstrating that human inventors, not models, performed the core inventive acts that patent law protects. Technical Playbook: Documenting authorship across AI-driven content chains. For marketing, product design, and media workflows, the emerging copyright framework demands an equally structured approach to authorship. The latest US guidance and commentary underline that mere prompting, without meaningful creative control, is insufficient, whereas iterative selection, editing, and combination of outputs can support protection for the human-created aspects of the work. Action points include implementing layered content logs that capture each generative step, prompts, model versions, seed images or text, and subsequent human edits, enabling a future tribunal to see where human expression begins and how it shapes the final work. Separating commodity content, where protection is less critical, from core brand assets, where human creative involvement and manual refinement are mandated by internal policy to preserve registrability and enforceability. Where registration is available, rights holders are increasingly advised to disclose AI involvement and confine the claim to human-authored portions, aligning with registration practices signaled by copyright offices. This calibrated disclosure reduces the risk of later invalidation for misrepresentation while still securing a meaningful scope of protection around the genuinely human contribution. Model and data provenance: Building a chain of title for AI. Model provenance now functions as an operational analog to the chain of title in transactional IP practice. Enterprises adopting generative AI at scale are expected to know and be able to evidence at least 4 layers: upstream training data sources, licensing or statutory bases for their use, model versions and fine-tuning datasets, and downstream output handling policies. Recent policy papers and industry alerts emphasize several high-risk patterns. Large-scale web scraping that ignores terms of use, removal of rights management information or circumvention of technical protection measures, and unvetted reliance on commercial APIs with opaque training disclosures. To address this, sophisticated adopters are moving toward segregated gold datasets that are fully rights-cleared and reserved for mission-critical or externally exposed outputs. Internal registries of model versions, training runs, and associated licenses, including restrictions on derivative training, redistribution, or use in specific verticals. For law firms, this provenance layer is becoming a due diligence line item in technology transactions, MANDA, and large licensing deals, where acquirers now demand representations, warranties, and audit rights covering training data and model development histories. Failure to maintain such records can depress asset valuations or lead to indemnity carve-outs that materially shift risk back to sellers and vendors. Contractual architecture, allocating AI-related IP and risk. The contract stack around generative AI has rapidly evolved beyond simple IP ownership clauses toward more granular risk allocation. Model providers increasingly limit or exclude indemnities for claims linked to training data or particular categories of use, while enterprise customers seek enhanced assurances for regulated or brand-sensitive deployments. A contemporary AI-ready IP clause set typically addresses distinctions between ownership of models, fine-tuning weights, prompts, logs, and outputs, with explicit allocation of rights in improvements derived from customer data. Carve-outs for use in training other models on customer prompts or outputs, often prohibiting such use for confidential or proprietary material, subject to narrow operational exceptions. On indemnity and limitation of liability, sophisticated parties introduce differentiated regimes for third-party IP claims tied to training corpora, on the one hand, and output-specific infringements or misuses on the other. This contractual differentiation mirrors the technical lifecycle and ensures that the party best positioned to control a given risk surface, developer versus deployer, bears the primary responsibility. Governance, compliance, and internal controls. Regulators and standard-setting bodies increasingly treat AI IP risk as part of broader AI governance obligations, linking it to security, privacy, and safety considerations. Industry guidance stresses that boards and senior management should oversee AI risk frameworks that explicitly include IP and data provenance dimensions, not just ethics or bias. Effective internal controls for generative AI typically combine centralized AI approval and registration processes, where each significant use case is classified by AI criticality, training data sensitivity, and exposure profile. Mandatory playbooks for permissible inputs, e.g., restrictions on uploading trade secrets or licensed content, required record-keeping, and pre-release checks for high-value outputs, including human review for potential infringement or leakage. These controls are increasingly supported by technical measures such as watermarking, logging, access controls, and automated screening of outputs for similarity to known third-party content, all of which intersect with IP enforcement and evidence generation. For law firms, embedding such frameworks into client counseling shifts the focus from isolated opinions to continuous advisory relationships around AI-enabled innovation programs. Forward-looking considerations for global adopters. For global players, the strategic horizon over the next 3 to 5 years is defined less by a wholesale rewriting of IP statutes than by incremental clarification through agency guidance, appellate jurisprudence, and soft law standards around AI transparency and data use. Emerging trends indicate tightening expectations on documenting human contribution, disclosing AI assistance in registration and prosecution, and demonstrating lawful training and deployment through traceable provenance. Corporations, SMEs, and law firms that treat generative AI not as a disembodied black box, but as a layered system with auditable human, data, and model components will be best positioned to convert AI adoption into durable, enforceable IP portfolios. The technical IP playbook for generative AI adoption, therefore, rests on 3 imperatives. Engineer human contribution into the innovation and creative pipeline, operationalize provenance as a first-class compliance artifact, and hardwire these principles into contracts and governance so that they scale as models and use cases proliferate. In short, in 2026, sophisticated IP organizations will converge on 5 principles: provenance by default, evidence before claims, human contribution as a documented asset, rights-aware AI architectures, IP governance embedded in product design. Conclusion: generative AI does not abolish IP law, it exposes its weakest assumptions. In the AI era, enforceability belongs not to the most creative, but to the most provable. Organizations that treat inventorship, authorship, and model provenance as engineering problems, designed, logged, and audited, will convert Gen AI from legal uncertainty into strategic advantage. Those that do not will discover that innovation without evidence is indistinguishable from infringement.
Page 26. Advertisement. 2026 AI PPI midterm meeting. Marrakesh, Morocco. 5th and February 6th, 2026. Mark your calendars for 5 to 6 February 2026 as the AI PPI midterm meeting heads to the vibrant city of Marrakesh, Morocco. Nestled at the foothills of the Atlas Mountains and rich in culture, color, and history, Marrakesh promises an unforgettable setting for our first gathering of 2026. Join us for 2 days of thought-provoking panel sessions and dynamic social events designed to inspire connections, foster dialogue, and share insight with industry leaders. 2026 AI PPI World Congress, Hamburg, Germany, 7th to October 10th, 2026. The 2026 AI PPI World Congress will be hosted in the vibrant city of Hamburg, set against the backdrop of its distinctive architecture and rich cultural heritage. Known for its dynamic cultural scene, maritime history, and innovative spirit, Hamburg offers a unique blend of modernity and tradition. This promises to be an unforgettable experience with a series of insightful discussions, engaging social events, and plenty of networking opportunities. It is the perfect setting to connect with leading experts, share innovative ideas, and gain valuable insights into the ever-evolving world of intellectual property. www.aippi.org.
Page 27. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Reimagining IP Services in the AI Era, a Human-AI Collaborative Future. Subheading: Heidi M. Kawand, founder and CEO at AIP Genius, Bahrain, poses the ultimate question when it comes to AI v. humans. Is it an existential battle or a transformative partnership? The discussion surrounding the exponential growth of artificial intelligence, AI, particularly within sophisticated, knowledge-intensive fields, has historically been framed as a zero-sum contest. This narrative often posits a stark, binary outcome: either a future in which autonomous, superior machines render human expertise obsolete, or one in which professional resistance successfully enforces a status quo of human-exclusive domain. The current wave of AI advancement, propelled by large language models and sophisticated machine learning, has reignited this debate across every knowledge-driven sector, from law and finance to medicine and the creative arts, and perhaps most acutely within the realm of IP services. Yet, an increasingly compelling and voluminous body of global evidence, supported by successful early implementations and strategic foresight from industry leaders, points to a profoundly different, and far more productive, conclusion. The future of these complex domains is neither machine-dominated nor human-exclusive, it is decisively collaborative. This emerging reality transcends the simplistic fear of replacement, advocating instead for a symbiotic relationship where human judgment, creativity, and ethical reasoning are augmented, amplified, and accelerated by AI's computational power, efficiency, and data processing capabilities. This human-AI collaborative paradigm is poised to redefine productivity, innovation, and service delivery standards. Recent research illustrates this shift. A 2024 study by Luther, Kimmel, and Kress demonstrates that AI-human collaboration significantly improves both efficiency and quality across complex cognitive tasks such as writing, analysis, and reasoning. Their findings reinforce a practical truth that AI delivers maximum value not when working alone, but when paired with human judgment. Benchmarking studies consistently reveal that synergistic human-AI collaborative systems significantly outperform either component operating in isolation. This integrated approach, often termed augmented intelligence, is defining the next generation of professional services, particularly within the IP sector. The optimal division of labor is becoming increasingly well-defined and strategically implemented across various IP workflows as AI excels at data-intensive and repetitive tasks. AI demonstrates unparalleled proficiency in tasks that require massive computational power, pattern recognition, and relentless consistency. Its core strengths include processing large datasets and document review. AI can ingest, parse, and structure millions of patent documents, legal filings, and technical specifications in a fraction of the time a human team would require. This is critical for prior art searches, freedom to operate analyses, and large-scale portfolio audits. Generating structured drafts and summaries. Algorithms can produce initial drafts of non-substantive sections of patent applications, e.g., background, summary of the invention based on claims, highly structured reports, and concise summaries of complex legal documents, providing a substantial head start for human professionals. Classification and categorization. AI models are highly effective at classifying inventions by technology area, IPC, CPC codes, categorizing legal correspondence, and sorting evidence in litigation support, ensuring high precision and uniformity across a database. Identifying anomalies and risk detection. AI's ability to spot subtle deviations from established patterns, such as unusual filing activity, potential infringement risks in the marketplace, or inconsistencies in claim language, acts as a powerful early warning system for IP owners. Humans remain essential for contextual interpretation and strategic depth. Despite the advancements in AI, the core value proposition of IP professionals, judgment, strategy, and client relationship management, is irreplaceable. Human capabilities are crucial for contextual interpretation and substantive legal analysis. Humans alone possess the nuanced understanding required to interpret ambiguous legislative text, apply evolving case law, and bridge the gap between technical details and their legal implications in a specific commercial context. Ethical evaluation and jurisprudence. Strategic advice requires ethical consideration, assessment of reputational risk, and alignment with evolving societal values, areas where algorithmic decision-making is inherently insufficient. Strategic decision-making and portfolio management. Formulating a global IP strategy, deciding whether to litigate or settle, identifying white space for innovation, and managing complex licensing negotiations are fundamentally strategic, human-driven exercises. Domain-specific nuance and client communication. The ability to communicate complex legal and technical concepts clearly to diverse stakeholders, inventors, business leaders, legal counsel, and apply deep, domain-specific knowledge to non-standard cases is a hallmark of expert human service. As Sohar et al. 2023 note, well-designed human-AI interfaces enable genuinely interactive workflows in which each collaborator contributes where it is strongest. The conclusion is straightforward: AI empowers, it does not replace. Yet this empowerment comes with caveats. As Bullock, 2020, emphasizes, AI is inherently a double-edged sword. While it enhances analytical capacity and accelerates routine tasks, it also introduces risks when deployed without appropriate oversight. These risks include hallucinated or unreliable outputs, data privacy vulnerabilities, opacity in decision pathways, and over-reliance on automated systems. For IP professionals, these challenges require deliberate governance. Legal-grade datasets, validation mechanisms, and human-in-the-loop review processes are essential to ensure accuracy, maintain ethical integrity, and preserve the professional accountability on which the IP system depends. Ultimately, the value of human-AI collaboration in IP services lies not in automation alone, but in synergy. AI contributes speed, scale, and pattern detection. Humans contribute interpretation, creativity, strategy, and ethical reasoning. Together, they enable more informed, more efficient, and more resilient decision-making without compromising the rigorous standards the IP ecosystem demands. The future of IP is therefore not a binary choice between humans and machines. It is the emergence of a hybrid model in which AI accelerates what it does best, and humans elevate what only they can deliver. This collaborative paradigm is reshaping how IP professionals work, strengthening both productivity and precision while keeping judgment squarely in human hands. The next era of IP will be built on this partnership, not competition, between human expertise and AI. Page 29. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: All Talk, No Consent, AI Voice Cloning and IP. Subhead: Zafira Hudani, reporter for Northern's Media PR and Marketing, UK, explores how courts worldwide are responding to AI-generated voice cloning and the legal limits of technological imitation. The uptick in AI use, particularly its breadth of application, continues to scale. Among the most controversial applications is voice cloning, in which AI is used to replicate real people's voices, often without consent. These developments raise serious concerns for IP, namely copyright, and personality rights, especially in the entertainment industry. A person's voice is closely tied to their identity. For actors, singers, content creators, and broadcasters, it is also a valuable commercial asset. As AI makes it easier to reproduce voices with high accuracy, legal systems around the world are being forced to consider how existing laws apply to this new technology. This article looks at how different regions are responding to the unauthorized use of human voices, with a focus on AI-generated voice replication. United States. In the United States, there is no federal law that protects the right of publicity. Instead, it is governed by state law. As a result, the level of protection varies. New York recognizes a statutory right of publicity, while California provides both statutory and common law protection. Courts have long recognized voice misappropriation. In Midler v. Ford Motor Company, 1988, the court found that using a sound-alike singer to imitate Bette Midler in a commercial infringed her rights, even though her actual voice was not used. The growth of AI has forced the legal system to adapt to technological advancements and prompted new legislation. In July 2024, Tennessee introduced the Elvis Act, Ensuring Likeness, Voice, and Image Security Act, becoming the first state to explicitly protect voices from unauthorized AI use. More recently, Lemon v. Lovo, 2025, dealt directly with AI voice cloning. The court applied New York civil rights law sections 50 and 51, which prohibit the unauthorized commercial use of a person's name, image, likeness, or voice. The court found that the AI-generated voices were recognizable as the plaintiff's and used for commercial purposes, reinforcing that existing publicity laws can apply to AI technologies. Europe, Germany. Across the European Union, the EU Artificial Intelligence Act, EU AI Act, plays a key role in regulating AI-generated content. A person's voice is generally treated as personal or biometric data, triggering both privacy and AI compliance obligations. One important feature of the Act is its transparency requirement, which requires AI-generated content, such as synthetic voices, to be clearly labeled as such. German courts have already applied these principles. In a recent case involving voice actor Manfred Lehmann, a German court ruled that YouTube unlawfully used an AI-generated voice resembling Lehmann's without his consent for commercial purposes. The court issued a cease and desist order, ordering YouTube to stop its use, and awarded Lehmann a license fee under unjust enrichment rules. India. In India, entertainers hold significant cultural and commercial influence. This makes unauthorized use of their identity, especially through AI, particularly impactful. In Arijit Singh v. Codable Ventures LLP, 2024, the Bombay High Court addressed voice cloning for the first time. The court ruled that the unauthorized use of Singh's voice violated his personality rights and right of publicity. It also confirmed that using an artist's name, voice, image, or likeness without consent for merchandise or digital assets is unlawful. This decision builds on DM Entertainment v. Baby Gift House, 2010, which established that celebrities have the right to control the commercial use of their persona. Together, these cases make it clear that Indian courts view voice as a protected part of personal identity. The Caribbean. In the Caribbean, courts recognize the tort of appropriation of personality, which protects a person's identity, including name, likeness, or other personality traits, from unauthorized commercial use. In the Robert Marley Foundation v. Dino Michel Limited, the Jamaican Supreme Court confirmed that even the potential commercial exploitation of a person's likeness can be actionable. In Georgia Messam v. Morris and Williams, the court clarified that this protection is not limited to celebrities. While there are no reported cases involving AI voice cloning yet, existing case law suggests that Caribbean courts would likely extend personality rights to protect human voices from unauthorized AI use. Looking ahead. As AI continues to develop, the protection of the human voice is becoming a key issue in IP law. Across jurisdictions, courts and lawmakers are recognizing that a voice is a central part of personal identity and deserves legal protection. While AI can replicate sound, it cannot replace ownership. The global legal trend is clear: technological innovation does not override the right of individuals to control how their voices are used. Page 31. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Robotics Patent Landscape 2025, Global Trends, Emerging Technologies, and AI-Driven Insights. Subhead: Claire Gibson, Senior Patent Analyst at Patworld, UK, with analytical contributions from Geraint James, Senior IP Manager, examines the shifting landscape shaping tomorrow's intelligent automation. Robotics continues to evolve at an extraordinary pace, shifting from a largely industrial domain into a diverse, AI-infused technological ecosystem. Patent filings provide one of the clearest indicators of where this evolution is taking place, revealing not only technological momentum but also regional strengths, emerging directions, and the scale of global investment. Using Questel analytics across more than 100,000 robotics-related patent families, search term Robotic Plus in titles, abstracts, or claims, this analysis examines filing growth, the technologies shaping innovation, and the increasingly important role of artificial intelligence within the robotics landscape. Through collaboration with Geraint James, Senior IP Manager at Patworld, the analysis was expanded with an AI-specific dataset comparing general robotics filings with AI robotics filings derived from AI-related IPC classes and machine learning terminology. This additional layer helps build a clearer picture of how robotics and AI intersect and where innovation is accelerating most rapidly. Chart 1. Robotics Filing Trend, General Robotics Landscape. General robotics filings have grown steadily for nearly 3 decades. From 1995 to around 2010, patenting activity increased gradually, reflecting ongoing improvements in industrial automation and the widespread adoption of fixed-function robots. Around 2015, however, the trend changes dramatically. Filing volumes begin to accelerate quickly, climbing from around 2,000 families in 2015 to more than 11,000 by 2024. The slight drop at the end of the dataset can be attributed to the standard 18-month publication delay rather than any indication of reduced activity. Several factors contribute to this long-term acceleration. Hardware has become substantially cheaper and more capable, with improvements in sensors, processors, and lightweight materials reducing the barrier to entry for robotic solutions. Collaborative robots, cobots, have also enabled robotics to move beyond fenced-off industrial spaces into closer human-machine environments, increasing their adoption across sectors such as logistics, retail, food processing, and medium-volume manufacturing. The demand for automation has grown sharply following global supply chain challenges, workforce shortages, and shifts toward e-commerce. At the same time, advanced computer vision, improved control systems, and more accessible autonomy frameworks are making robotics deployments more flexible. Together, these trends suggest that robotics innovation is moving from rigid, rule-based machinery toward systems capable of adapting to their environments and performing increasingly complex tasks. While specific technologies may appear more frequently in searches using the term robotic, the overall trajectory remains clear. Robotics innovation is expanding rapidly across multiple industries and use cases. AI robotics, a deeper look into emerging intelligence. To better understand the role that artificial intelligence plays within this landscape, a second dataset was constructed using AI-related IPC classes combined with machine learning keywords such as neural networks, image recognition, and reinforcement learning. This allowed direct comparison between filings where AI is central to the invention and the broader robotics field. This AI-focused dataset highlights several fundamental shifts. It shows that the fastest growth within robotics is occurring in technologies that rely heavily on perception, decision-making, and autonomous behavior. Whereas earlier generations of robotics centered on mechanical precision and repeatable motion, the newest developments increasingly rely on software, data, and learning-based systems. This is consistent with industry trends, where robotics is moving closer to AI-enhanced autonomy, enabling robots to operate with greater independence and reduced reliance on pre-programmed instructions. Chart 2. AI robotics filing trend, steeper and software-led. When viewed alongside the general robotics dataset, AI robotics filings show a noticeably steeper trajectory. This suggests that AI-enhanced robotics is not simply keeping pace with the sector but is growing faster than robotics overall. Several themes emerge. AI technologies are becoming central to innovation in robotic systems. Perception-driven robotics, autonomous navigation, and learning-based control are driving much of the recent growth. Companies are increasingly focusing on robots that understand their surroundings rather than those that simply perform predefined motions. In line with this, the AI robotics dataset shows significantly higher representation in software-centric IPC classes, including G06T, image processing and machine vision, G06N and G06F, machine learning, neural network systems and computational intelligence, G05B, control and decision-making systems. These classifications illustrate how much modern robotics depends on software rather than mechanical innovation alone. As robots become more autonomous, the proportion of filings describing algorithms, data-driven control methods and learning techniques is likely to continue increasing. This is reflected in both the filing volume and the rapid pace at which AI robotics innovation is rising. Chart 3. Territorial comparison, AI robotics vs general robotics. One of the most meaningful differences between the datasets appears in the territorial breakdown. While China remains dominant in robotics overall, driven by sustained investment in industrial automation and large-scale manufacturing, its share decreases in the AI robotics subset. Instead, the United States shows a significant rise in relative activity when focusing specifically on AI-enabled robotics. This shift is aligned with several well-known strengths in the United States, including AI research and development, machine learning infrastructure, software-led robotics and autonomous systems, academic industry collaboration around AI. Japan and South Korea retain strong profiles in precision manufacturing, robotics hardware, and consumer robotics, although their proportion of AI-specific filings is somewhat lower than that of the United States. Europe, meanwhile, displays a balanced presence across both datasets, reflecting its strength in industrial automation, medical robotics, and regulation-led safety technologies. This territorial distinction highlights the ways in which robotics leadership differs depending on whether the focus is on mechanical innovation or intelligence-driven capability. As autonomous systems become more mainstream, these regional specializations will play an increasingly important role in global competitiveness. Technology landscape observations. Across the general robotics dataset, several technological domains stand out. Material handling and logistics, medical and surgical robotics, welding and machine tool systems, safety and control systems, imaging and sensor-based robotics. These reflect the broadening of robotics from traditional manufacturing into healthcare, warehousing, transportation, and inspection. When the landscape is filtered to focus on AI robotics, however, the emphasis shifts noticeably towards software-intensive technologies, including perception and environmental understanding, learning-based control, navigation and autonomous mobility, decision support algorithms, integrated systems combining sensing, learning, and control. As observed by Geraint James, this difference reflects a larger trend within robotics, The most dynamic areas of innovation increasingly rely on intelligence rather than mechanical capability alone. Robots are evolving into platforms that integrate sensing, software, and decision-making, with hardware as one component of a broader intelligent system. Chart 4. Legal status comparison, AI robotics vs. full robotics. The legal status comparison offers further insight into the maturity of each domain. AI robotics patents have a much higher proportion of pending applications and comparatively few dead filings. This indicates a young and active technology area with strong current investment and a long runway of ongoing development. By comparison, the general robotics dataset contains more granted and expired patents, reflecting longer market presence and a more established competitive environment. For organizations planning future robotics strategies, this split suggests that AI robotics is likely to remain a major focal point for research, investment, and IP activity over the coming years. Strategic implications for innovators and IP professionals. The combined datasets offer several strategic insights. 1. AI robotics is an emerging high-value segment. Steeper filing growth and high volumes of pending patents signal strong commercial investment. Companies moving into AI-driven robotics should expect increasing competition. 2. Dual discipline claiming is essential. Modern robotics inventions combine hardware and software. Protecting such systems requires claims that capture mechanical elements, algorithmic behavior, and sensor integration logic. 3. Territory-specific strategies matter. China's dominance in mechanical robotics and the U.S.'s strength in AI robotics require tailored territorial patenting and freedom to operate strategies. 4. AI-centric portfolios will differentiate tomorrow's robotics leaders. Companies investing in autonomous decision-making, vision-based navigation, and learning-enhanced control systems are shaping the competitive landscape. 5. AI robotics may be a hot litigation zone. The high proportion of pending AI robotics patents, compared with mature robotics fields, suggests that disputes, once products become widespread, may be more common in AI-heavy domains. Conclusion. The robotics sector continues to evolve rapidly, with AI robotics accelerating even faster than mechanical robotics alone. The shift toward intelligent, autonomous systems is reshaping innovation priorities and competitive dynamics across industries. With AI-driven software becoming central to robotic systems, and the legal status data showing intense, ongoing filing activity, AI robotics represents one of the most important emerging frontiers in the global IP landscape. This combined analysis, developed by Claire Gibson with additional analytical contributions from Geraint James, provides a clearer understanding of where robotics innovation is heading and how organizations can position themselves strategically in this fast-moving sector.
Page 36. Advertisement. Brand Protection Congress. Empowering businesses to protect their brands. 15th and April 16th, 2026, London, UK. info@worldbigroup.com.
Page 37. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Recent Developments in Copyright Jurisprudence in Sri Lanka. Subhead: Anomi Wanagasekara, Senior Partner, and Sabira Sharif, Senior Associate, of Julius & Creasy, Sri Lanka, review a landmark copyright ruling by Sri Lanka's Supreme Court involving the works of a musician, which clarified economic and moral rights. Intellectual creations, original in nature and fixed in a tangible form of expression, attract copyright protection. The law relating to copyright in Sri Lanka is set out in the IP Act, No. 36 of 2003, and the regulations made under it. There is no mechanism for copyright registration in Sri Lanka. However, Sri Lanka is a contracting party to the Berne Convention for the Protection of Literary and Artistic Works, and thus works of Sri Lankan authors are protected in all the member countries of the Berne Convention. Subject to certain limitations, original intellectual creations of a literary, artistic, or scientific nature, as defined under the IP Act, are protected works in Sri Lanka. Creators are entitled to economic rights and moral rights for their original intellectual works. Enforcement of copyright could be through both civil and criminal action. In a civil action, any person who infringes or is about to infringe copyright may be restrained from doing so by way of an injunction and be liable to damages. The judgment of the Sri Lankan Supreme Court delivered on the 23rd of May 2025 in Sheila Wijewardene v. Sorath Kothalawala and Rajiv Sebastian could be considered a landmark decision regarding copyright in Sri Lanka. In this case, the plaintiff appellant, Sheila, was the spouse of the late legendary Sri Lankan musician Clarence Wijewardene. She initially filed a case against the two defendants in the Commercial High Court of Sri Lanka, claiming that the economic rights of her late husband were infringed and that several musical works had been distorted, thereby violating the moral rights of those compositions. However, before the trial commenced, the second defendant, Rajiv Sebastian, reached a settlement with the plaintiff, whereby he paid compensation in a sum that was much less than the damages claimed in the plaint and admitted the IP rights of her late husband. The case proceeded to trial against the first defendant, Sorath Kothalawala, and the court found in favor of the plaintiff, holding that the IP rights, both economic and moral, belonged to the late Clarence Wijewardene's estate and that the first defendant had infringed those rights. Although the plaintiff prayed for several reliefs, the court granted only two reliefs against the first defendant, namely a permanent injunction and the costs of the action. It refused to grant the other reliefs prayed for, i.e., damages, delivery of infringing material, accounts to the plaintiff of the profits made by the defendants attributable to the infringement, and payment of such profits to the plaintiff. The appeal to the Supreme Court was made in respect of the reliefs not granted by the Commercial High Court. The Supreme Court partly allowed the appeal and granted the order for the delivery of the infringing material but refused to grant damages and profits made by the first defendant. It was apparent that the court was reluctant to set aside the order of the Commercial High Court in respect of the claim for damages, given that the first defendant had entered into several agreements with the second defendant, who later compromised the action with the plaintiff. Under the said agreements, the second defendant accepted all liabilities arising therefrom. The Supreme Court reasoned that due to the compromise of the second defendant, what may be decided as his respective liability in terms of Section 14 of the Civil Procedure Code by the judge has been settled for an agreed value by the parties to the settlement. The court has concluded that Section 14 of the Civil Procedure Code empowers a judge to consider, on the evidence available to the judge, the respective liabilities of each defendant, even where joint liability is pleaded. The court was also of the view that the IP Act allows the court to limit damages to profits or to pre-established damages where the infringer did not know, or had no reasonable cause to know, that they were engaged in an infringing activity. Generally, the amount of damages is fixed, taking into account inter alia, the importance of the material and moral prejudice suffered by the owner as well as the importance of the infringer's profits attributable to the infringement. The Supreme Court also held that where infringement is proven, the delivery of infringing material in the possession of the defendants should be given, and that for an award of profit earned through the infringement, the figures have to be proved. As the plaintiff had not taken any steps at the Commercial High Court to prove profits, the court was not in a position to verify the accounts, and it could not be done during the appeal. Therefore, it is evident that the judgment comprehensively addresses many aspects of copyright infringement and matters incidental thereto, thereby contributing to the development of precedent in Sri Lankan copyright law. Page 39. Article. Disclaimer. Images and references related to this article can only be seen in the print and digital versions of the magazine. Title: From Fragmentation to Foresight, Why Data is the Missing Foundation of Global IP Quality. Subhead: Kerry Levitt, Strategic Advisor at Azami Global, US, looks at how connected data transforms global IP quality from reactive management to system-level foresight. Global IP's structural blind spot. For decades, the IP profession has demonstrated an exceptional ability to manage complexity. IP practitioners routinely navigate different legal systems, languages, procedural standards, and timelines with a level of precision that few other professional disciplines are required to maintain. Global IP work demands coordination across borders, technologies, and commercial objectives, often under significant time pressure and regulatory constraint. Yet despite this sophistication, global IP operations today remain constrained by a structural weakness that is rarely addressed directly: fragmented data and disconnected decision-making. As IP portfolios have expanded in size, geographic reach, and strategic importance, the systems that support them have not evolved at the same pace. Information critical to decision-making is dispersed across emails, spreadsheets, local databases, vendor portals, and individual relationships. Decisions are frequently made with partial visibility, relying on experience and intuition where data is incomplete, inconsistent, or inaccessible. Over time, this fragmentation quietly undermines quality, predictability, and trust, even in organizations that are otherwise well run. This challenge is not the result of insufficient expertise or commitment. On the contrary, IP professionals consistently compensate for systemic gaps through diligence, institutional knowledge, and personal effort. The issue is structural rather than individual. Global IP has scaled significantly over the past 2 decades, but the way information is connected, preserved, and used has not kept pace with that growth. Scale without systems. Today's IP environment operates at unprecedented scale. Corporations manage portfolios that span dozens of jurisdictions, technologies, and commercial priorities. Law firms coordinate filings, prosecutions, oppositions, and renewals through complex networks of foreign associates. Regulatory requirements evolve continuously, filing volumes increase, and timelines compress. The pace of activity accelerates year after year, placing additional pressure on already stretched teams. At the same time, portfolios are becoming more dynamic. Assets are reassessed, divested, licensed, or expanded more frequently in response to shifting business priorities. IP is no longer static. Yet the data that informs these decisions often remains static, locked in formats and systems designed for an earlier era. Institutional memory is fragmented, and historical context is difficult to retrieve without manual effort. Handoffs between stakeholders further compound the problem. Information moves between corporates, outside counsel, foreign agents, and internal teams, often losing structure and clarity along the way. Each participant may hold part of the picture, but rarely the whole. Without shared visibility, coordination relies on repetition and trust rather than evidence and insight. When operational assets remain disconnected, IP management becomes transactional rather than systemic. Decisions are made in isolation, often optimized for local efficiency rather than global coherence. Learning remains local rather than institutional. Improvement depends disproportionately on individuals rather than on processes or systems. Over time, this creates fragility that is difficult to detect until something goes wrong. Scale also introduces a less visible challenge: continuity. As portfolios grow, decisions made years earlier continue to shape outcomes long after the individuals involved have moved on. Without connected data, context is lost, and reasoning must be reconstructed. New teams inherit results without understanding the decisions behind them. Over time, organizations become reliant on institutional folklore rather than documented insight. This undermines confidence and slows progress. Systems do not replace experience, but they preserve it. In an environment defined by scale, continuity becomes a prerequisite for effective governance and long-term quality. When flexibility becomes fragmentation, fragmentation is often defended as flexibility. Decentralization has long been a defining feature of global IP practice, and for good reason. Local expertise matters. Jurisdiction-specific knowledge, language skills, and professional relationships are essential to effective IP management. However, decentralization without shared data and standards can easily become fragmentation disguised as autonomy. In practice, this leads to significant variation in how similar decisions are made across regions or offices. Agent selection may depend more on historical familiarity than on comparative performance. Cost structures differ without clear explanation. Quality is assumed rather than measured. Without comparable data, it becomes difficult to evaluate whether outcomes are consistent or whether risks are accumulating unevenly across the portfolio. Flexibility without visibility is not a strategy. It limits accountability and obscures risk. For IP leaders, the challenge is not choosing between centralization and decentralization, but ensuring that decision-making across the organization is informed by coherent, comparable information. Without that foundation, even well-intentioned decisions can produce unintended consequences.
Page 40. Advertisement. IP Tech and Innovation Services Annual. Recognizing the game changers, redefining innovation, and driving support across the world of intellectual property. Connect with IP professionals ready to explore and adopt technologies that are reshaping how IP is managed, protected, and delivered. Make your IP technology impossible to miss. Feature in the 2026 IP Tech and Innovation Services Annual and engage IP professionals around the world. Secure your place for the 2026 debut. Exclusive sponsors: LexisNexis. Email: technovation@northonsprmarketing.com. +440-2038-130457. www.iptechnovation.com.
Page 41. Article continue. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Why quality becomes reactive. The consequences of fragmented data are most visible in how quality is managed. Too often, quality in IP is assessed reactively. A missed deadline, an unexpected office action, a renewal surprise, or a cost overrun becomes the trigger for review. While these moments are important, they are symptoms rather than root causes. Reactive quality management shapes behavior in subtle but significant ways. Teams focus on resolving immediate issues rather than addressing underlying patterns. Reviews are conducted in isolation, without sufficient context to identify systemic contributors. Over time, this fosters a culture of response rather than prevention. Disconnected data makes it difficult to spot early warning signs. Minor inconsistencies in outcomes, costs, or timelines may go unnoticed until they escalate. By the time an issue becomes visible, options are often limited. Corrective action is more expensive, more disruptive, and more reputationally damaging than preventative insight would have been. Proactive quality requires visibility. It depends on the ability to observe trends across jurisdictions, agents, and decision points. It requires data that is structured, comparable, and accessible across the organization. This does not diminish professional judgment. On the contrary, experienced practitioners are best positioned to interpret data, identify nuance, and apply context, but only when the underlying information is reliable and connected. Over time, reactivity reshapes expectations. Teams come to accept disruption as normal and escalation as inevitable. Reviews focus on individual events rather than systemic contributors. Lessons are discussed but not embedded. This cycle consumes attention and limits strategic thinking. More importantly, it shifts the definition of quality itself, from prevention to recovery. In such environments, success is measured by responsiveness rather than foresight. Breaking this cycle requires more than effort. It requires visibility that allows organizations to see patterns early and act before issues harden into outcomes. The hidden operational cost. The cost of disconnected workflows extends well beyond legal outcomes. Fragmentation affects confidence, communication, and scalability across the entire IP ecosystem. For law firms, it complicates client conversations. Even when decisions are sound, the absence of documented rationale makes it harder to explain outcomes, costs, or strategic choices with clarity and confidence. Over time, this can erode trust, particularly as clients demand greater transparency. For corporate IP departments, fragmented data undermines forecasting and planning. Budgets become reactive rather than strategic. Risk assessment relies on anecdote rather than evidence. As portfolios grow, internal teams face increasing operational strain as they attempt to reconcile information held in multiple formats, systems, and jurisdictions. In my role at Azami, working across a wide range of firms, corporates, and agent networks globally, I consistently see highly capable professionals compensating for fragmented systems through personal effort. They track information manually, maintain parallel records, rely on memory, and bridge gaps informally. While effective in the short term, this approach does not scale and exposes organizations to risk when individuals change roles, retire, or leave. Expertise needs infrastructure. Human expertise remains the foundation of IP practice. Relationships, judgment, and experience are irreplaceable. The profession has long prized craftsmanship and individual mastery, and rightly so. However, craftsmanship alone cannot carry the operational demands of modern global IP. As portfolios grow and teams become more distributed, leadership responsibility shifts. It is no longer sufficient to rely on individual excellence. Leaders must also invest in the infrastructure that allows expertise to be applied consistently and sustainably. Without that infrastructure, even the best practitioners are forced into reactive modes of work. Expertise unsupported by structured, connected data places unnecessary strain on people and limits organizational learning. Knowledge becomes personal rather than institutional. Success depends on continuity of individuals rather than continuity of systems. This increases risk at precisely the moment when resilience is most needed. If global IP is to evolve, quality must be redefined. Rather than viewing quality solely as the outcome of individual actions, it should be understood as the result of a system. A system-based view of quality shifts the focus from isolated execution to repeatable, governable processes that support professional judgment. Infrastructure is often mistaken for administration, but in reality, it is an expression of leadership intent. It signals how seriously an organization takes consistency, accountability, and learning. When infrastructure is weak, expertise is consumed by coordination rather than judgment. When it is strong, professionals are freed to focus on higher value decisions. The difference is not technological sophistication, but organizational discipline. In global IP, leadership is increasingly defined not only by legal insight, but by the systems that allow insight to endure. From assets to outcomes. A modern understanding of IP quality rests on several principles. Visibility enables informed decision-making across jurisdictions without eliminating local discretion. Consistency allows organizations to compare outcomes meaningfully while respecting nuance. Accountability strengthens professional judgment by making decisions traceable to evidence rather than assumption. Continuity ensures that institutional knowledge persists beyond individuals, teams, or organizational changes. This reframing moves quality from something inspected after the fact to something designed into operations. It shifts the emphasis from firefighting to foresight, from reaction to governance, and from individual effort to organizational capability. The future of global IP will be shaped not by the number of tools adopted, but by how effectively operational assets are converted into meaningful outcomes. Leaders will distinguish themselves by their ability to anticipate risk, align stakeholders, and make decisions grounded in evidence rather than habit or precedent. For law firms, this presents an opportunity to differentiate through predictability, transparency, and governance, alongside legal expertise. For corporates, it offers greater control and confidence in how IP supports broader business objectives. Organizations such as IIPLA play an essential role in advancing this conversation by fostering shared thinking around standards, visibility, and system-level quality. A system-level challenge for the next era of IP. Fragmentation is not inevitable, but overcoming it requires deliberate effort to connect data, decisions, and outcomes into a coherent whole. Only then can global IP operations truly scale, not just in volume, but in quality.
Page 43. Advertisement. Women's IP World Podcast. Celebrating the work and achievements of women in IP law, and innovation worldwide. Discover an inspiring podcast series dedicated to spotlighting the remarkable women shaping the global intellectual property and innovation landscape. Each episode features powerful conversations, professional insights, and personal journeys that highlight leadership, expertise, and impact across the international IP community. Hosted by Michelle S. Katz. Founder, Advitum IP, LLC, Chicago, USA. Visit www.womensipworld.com. Page 44. Advertisement. Northon's Media PR and Marketing Ltd presents IP360 Hub, the Global Industry Profile Guide, connecting the global IP community. IP360 Hub connects IP professionals, law firms, and service providers through an affordable print and digital interactive networking platform. A new year, a new platform, a new level of visibility. Launching in January 2027. Enjoy complimentary 2026 digital access when you join today, ahead of the official 2027 print edition. Exclusive New Year offer, 35% savings. Full-page advert, £227, was £349. Service listing, £292, was £449. Full-page professional profile, £357, was £549. Use code NEWYEAR 35%. Valid until February 27th. IP360 Hub Handbook 2027, coming soon. Visit www.ip360hub.com. Email info@northonsprmarketing.com. Phone +440 2038130
Page 45. Article. Disclaimer. Images and references related to this article can only be seen in the print and digital versions of the magazine. Title, From Admin to Asset, How IP Teams and Law Firms Can Transform Operations Through Data, AI, Spend Management, and Strategic Alignment. Subhead, Nadine Stuttle, Founder and CEO, IP Technology, AI, Operations and Transformation Advisor at PSS Solutions, Switzerland, explains how in-house IP teams and law firms can move from administrative support to strategic business partners by harnessing data, AI, spend management, and governance to align IP with long-term enterprise value. IP has become a core driver of competitive advantage, yet in many organizations the IP function has historically focused on administrative workloads, filing and prosecuting applications, managing deadlines, paying annuities, and coordinating with outside counsel. Today's business environment demands far more. Rapid innovation cycles, rising costs, and global competition require IP teams to shift from reactive administrators to strategic partners who guide decision-making, influence investment, and support the strategic vision. This shift also profoundly affects IP law firms, which are increasingly expected not only to provide legal expertise but also to deliver analytics, technology-enabled efficiencies, cost transparency, and proactive strategic advice. Emerging technologies, particularly AI and agentic AI, are accelerating this transformation, reshaping what IP teams and law firms can deliver and how they collaborate. Historically, both in-house teams and law firms struggled with fragmented data, manual processes, and reactive workflows. Decisions about where to file patents, how to allocate budget, or which assets to abandon were often made in isolation, without access to comprehensive portfolio analytics or real-time competitive intelligence. As a result, portfolios grew inefficiently, prosecution costs mounted, and both sides found it difficult to articulate ROI or influence business strategy. AI and automation are now dismantling these barriers by turning unstructured IP data into actionable intelligence and reducing manual task loads that once consumed substantial time, resources, and cost. Data analytics remains central to the modern IP operation, but AI dramatically amplifies what analytics can be achieved. With AI-enabled search, automated landscape analysis, and predictive prosecution modeling, organizations can assess technology trends, map competitor activity, predict office action outcomes, and evaluate the value or vulnerability of assets far more quickly. Law firms are embracing these tools to provide deeper insights to clients, benchmarking prosecution outcomes across industries, forecasting costs with greater accuracy, and identifying filing strategies that minimize risk and optimize efficiency. In-house teams use AI to connect IP data with product, R&D, and financial systems, providing a more holistic view of how IP investments support business strategy. Agentic AI, systems that can autonomously execute sequences of tasks, represents an even more transformative shift. Rather than simply assisting with discrete tasks, agentic AI can orchestrate end-to-end workflows such as prior art searches, patent landscape scans, or annuity forecasting. For example, an agentic AI system could continuously monitor competitor filings, synthesize new technical documents, identify emerging threats, and notify portfolio managers with recommended actions. In prosecution, agentic AI could draft preliminary office action responses or generate claim variations based on examiner behavior and historical success rates. For law firms, agentic AI has the potential to streamline complex workflows such as multi-jurisdictional filings, routine correspondence, docket reconciliation, and even first-draft claim construction, allowing attorneys to focus more on strategy and advocacy. A threat to the law firm revenue stream, or a unique opportunity to embrace change, become technology-enabled and stand out from the competition. A key question all law firms must urgently address. Improving data quality remains a foundational prerequisite for advanced analytics and AI adoption. In-house teams often begin by conducting data audits, cleaning metadata, standardizing technology classifications, and integrating systems so data can flow seamlessly from R&D to legal to finance. Law firms play a critical role in this effort. Because they manage large volumes of prosecution data, they can help ensure accuracy by adopting structured reporting formats, automating updates from IP offices, and delivering clean, machine-readable data back to clients. AI tools trained on clean datasets can then produce more reliable insights and reduce the risk of error in automated tasks. Once data quality is improved, organizations can build KPIs that reflect both operational efficiency and strategic impact. Traditional metrics, filing timeliness, cycle time reductions, or office action response speed, remain important, but strategic KPIs gain new relevance with AI. Law firms can track the impact of AI tools on drafting quality, cost predictability, and reduced prosecution cycles. Shared KPIs across in-house teams and law firms help ensure alignment, while AI-powered dashboards provide real-time visibility into trends, costs, and risk indicators. As AI becomes embedded in IP operations, KPIs increasingly measure value created through automation, insights generated from analytics, and improvements in strategic decision-making. Spend management and procurement are also being transformed by technology and analytics. Rising prosecution and maintenance costs have pushed organizations to adopt more rigorous procurement practices, including firm rationalization, standardized pricing models, and alternative fee arrangements. AI and agentic systems enhance this discipline by enabling real-time cost tracking, predicting budget deviations, and identifying patterns that drive cost overruns. In-house teams can use AI to model different filing or renewal strategies, evaluating the cost implications of jurisdictional choices or varying response strategies. Law firms can use AI to improve their own cost structures, optimize internal workflows, and pass efficiency gains onto clients through more competitive pricing. Cost optimization extends to portfolio pruning as well. Many portfolios contain legacy or low-value assets that consume significant maintenance budgets. AI tools can evaluate each asset's relevance to current products, revenue impact, technology roadmaps, and competitive positioning. Agentic AI can run continuous portfolio scans, flagging assets that are underutilized or misaligned with strategy, and generating evidence-based recommendations for pruning or monetization. Law firms can provide additional analytical models to support pruning decisions, helping clients evaluate legal risks, enforcement history, and market trends associated with each asset. Together, these capabilities enable a more precise approach to spend management, ensuring investments are focused on assets that meaningfully support business objectives. The integration of AI and analytics also makes ROI measurement more sophisticated and defensible. ROI can be framed in traditional financial terms: licensing revenue, litigation successes, cost avoidance, or monetization of unused assets, but it increasingly includes strategic dimensions such as competitive blocking value, market access enablement, and risk mitigation. AI can model the expected impact of defensive publications, freedom to operate strategies, enforcement options, and brand expansion initiatives. Law firms can support ROI analysis by providing industry benchmarks, predictive litigation analytics, and monetization opportunities. As AI tools become more capable, ROI measurement shifts from retrospective evaluation to real-time forecasting and scenario modeling. These technological shifts are fundamentally reshaping the IP profession and how services are delivered across the IP ecosystem. The skills required of in-house teams are expanding from legal expertise to include data literacy, AI fluency, financial acumen, and cross-functional collaboration. Law firms are undergoing a parallel evolution. Many are investing in legal technologists, AI specialists, data scientists, and project managers to support their attorneys and enhance client service. Attorneys increasingly need to understand how AI tools generate insights, how to validate AI outputs, and how to integrate AI-driven recommendations into strategic counseling. Upskilling is therefore essential for both sides. In-house teams benefit from training in data analysis, AI model interpretation, financial modeling, portfolio strategy, and innovation processes. Law firms are developing internal training programs to help attorneys understand AI's capabilities and limitations, adopt new drafting and search tools, and engage in data-driven discussions with clients. Some firms provide training directly to client teams, supporting joint capability development and strengthening relationships. Governance frameworks tie all of these elements together by defining how decisions are made, who participates, and how AI is used responsibly. Effective governance establishes clear criteria for filing, renewal, and litigation decisions, integrates finance, R&D, and legal stakeholders, and ensures consistency and transparency. Governance for AI adds additional layers, including oversight of AI-generated recommendations, auditability of decision sources, safeguards against bias, and processes for validating model outputs. Law firms can support clients by helping develop these governance frameworks, advising on regulatory considerations, and providing their own AI use policies to reassure clients about confidentiality and model integrity. Ultimately, the future of IP management is collaborative, data-driven, AI-enabled, and strategically aligned. In-house IP teams and law firms that embrace these shifts will be uniquely positioned to deliver greater value, protecting innovation more efficiently, strengthening competitive advantage, optimizing spend, and enhancing business outcomes. AI and agentic AI won't replace IP professionals, but they will fundamentally change the nature of their work, elevating their roles from administrators of complex processes to strategic advisors guiding innovation, investment, and enterprise growth. Together, empowered by data and technology, IP teams and their law firm partners can create a high-performance ecosystem that transforms IP from a compliance obligation into a driver of long-term business success. Page 47. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Protecting Creativity in the Digital Age, a conversation with attorney Justin M. Jacobson. Subheading: IP and entertainment lawyer Justin M. Jacobson, founder of Justin M. Jacobson Law Office, sat down with Zafira Hudani, reporter at Northlands Media PR and Marketing, to discuss content creators' rights, navigating AI, and building sustainable creative businesses. Can you start by introducing yourself and how you came to the IP and entertainment law space? I have been involved in the entertainment and music space for nearly 2 decades now and have been an attorney for almost 15 years. During that time, I have worked for various labels and music publishers, and I've always felt that the creative world was one I wanted to be part of. IP protection, be it copyright, trademarks, or licensing, is the core of these media verticals. It is important to understand these protections and be well versed in them to advise clients in this space on these matters. I enjoy helping people achieve their goals by obtaining the proper protections for what they create. What advice would you give a client who is looking to create a YouTube channel or share content to help them protect their ideas? It is important to know which types of protection can be used for different assets, namely, copyright and trademarks. For instance, if you are a YouTube creator or a content creator in general, your handle, name, or username would be something that you might trademark. This would be similar to a musician or a sports team that trademarks their name. Similarly, you can trademark a series of content. Copyright protection may be used to protect songs, logos, and audiovisual works, for example. Understanding and potentially obtaining these protections allows clients to acquire ownership, preventing infringement and allowing them to license and monetize these assets. This is not legal advice. Entertainers and creators are primarily interested in sharing their content. Do you also provide information to support the business aspect of content creation? Yes, it is a comprehensive educational process that includes sharing knowledge about creating a business entity and understanding how finances work. Some of these creators are very young and may not be aware of the need to form a business entity, such as a corporation or LLC, or to open a separate business account. Early on, I had clients in the gaming and content creation industries who were unaware of the difference between a credit card and a debit card. This is because they are unfamiliar with the need for these things. In other industries, such as movies, music, and fashion, having a separate business account is more commonplace. When would you say that a creator-entertainer needs to establish themselves as a business? It will depend on why you are creating content. If it is for fun, you likely don't need one. If the intention is to develop and devote time and effort to sharing your creation, you may want to see it as a business. Generally, having all the necessary pieces in place to run a business will come into play if you are successful. It is a lot harder to play catch-up once you are successful. If you are successful in the future and do not have things in place, it will be much more expensive to fix. Artificial intelligence, AI, has a huge impact on this space. As a creator or entertainer, is it possible to use AI to create a new work? Issues surrounding AI and copyright protection are continuously evolving. A month from now, there may be legislation that changes things. But as we near the end of 2025, any contributions that are not created by a human being will not be given copyright protection. If you are using an AI program like Midjourney or another generative AI to create images or text, the only protectable elements will be the human contribution. In relation to the US Copyright Office, we have started to see that if you are looking to file an application for a work created using AI or that includes any AI elements, you must complete a disclaimer stating that AI was used in the creation of the work. In addition, you must document the human contribution, which is the portion of the work that actually gets the protection. An example of this is the Midjourney-generated AI comic book, which was the first work the US Copyright Office ruled on. The Copyright Office said that because the images were created purely with generative AI, a computer does not have rights in their creation. A computer is not a human, so it cannot be an author of a work. However, if there is a human element, for example, a person who edited a video, cropped an image, or assisted in story development, it might be protectable. The more you use generative AI, the fewer protectable elements you will have. I have started advising clients to use AI as a guide or tool to maintain the ability to apply for copyright protection for a work. An analogy is spell check in a document. You can use it, but the knowledge in the document comes from a human. Can you give an example of how you might advise a client using generative AI in their creations? I recently had a client who had used generative AI for video editing and other aspects of the work. We discussed how to make the work, in this case a character, more theirs to increase the human element. Similarly, if there are service providers such as graphic or web designers, it is important to include language in the contracts addressing the use of AI. The use of AI may affect the contractual terms governing indemnification. An example of this would be a service provider being sued for lacking proper licensing. In addition, it is important to disclose what was done with generative AI and what was done by a human. Online content is accessible globally. Do creators or entertainers need protection in different countries? The World Intellectual Property Organization, WIPO, has released its guidelines, but I think right now every country is developing its own approach to this. There is not really a uniform answer at this time. However, it is important to be aware of the different rules and protections applicable in jurisdictions where you have a lot of consumers. For those unfamiliar, can you explain what esports encompass? And what legal hurdles does the sport present? Esports is basically the professional video gaming world. It includes individuals or teams who compete in video games such as League of Legends, Call of Duty, Madden NFL, or Fortnite. These games have reached the point where tournaments offer millions in prize money, and people watch them in huge arenas. It has become its own type of entertainment vertical based on digital streaming and social media. Due to the sport's global nature, people from all over the world come to the US to participate in competitions or tournaments. You need a visa if you are coming to the US to earn money, including performing in a tournament where money can be earned or won, or securing a sponsor endorsement. I can help individuals and talent seeking to come to the US with the visa process. What experience have you had with non-fungible tokens, NFTs? I have not talked about NFTs in a while now, but we have seen some successful executions in this space. An example would be Kings of Leon with their 4 golden tickets. What is cool about the NFT space is the concept of limited editions and the increased value that comes from scarcity. It is possible to obtain protection for an NFT or similar asset, but only if done correctly. What advice would you give to someone looking to get into the entertainment and IP law space? I think, to quote Nike, just do it. The IP or entertainment law space sounds like fun, but you might not know what it includes until you actually get into it. So, the advice is to get into the ecosystem. If you want it, try to get your foot in the door by applying to law firms that have an IP team or department. I think LinkedIn and social media have made it easier to connect with many people. If you are looking to apply to law school, find a school with an IP program or take classes in the area. Where do you think the next challenges or changes in the IP space will come from? AI will be the top issue until it is resolved. Right now, the large entertainment companies like Warner Brothers and Sony are on one side, while the tech companies like Google and Apple are on the other. These companies have endless money. In this situation, things get interesting. I predict that it will come down to numbers. It is an economic balancing sheet and a risk tolerance issue. The implementation of state, national, or international legislation will determine a lot of things. At this point, AI has an impact on most jobs in the entertainment space and jobs in general. Disclaimer: Zafira Hadani is a New York licensed attorney. The information provided is for informational, educational purposes only. No legal relationship is formed by reviewing, accessing, or otherwise engaging with the information provided. Attorney advertising.
Page 50. Advertisement. Advert 1. The Caribbean IP Annual 2026. Promoting IP excellence in the Caribbean. Profile, regional reports, thought leaders. Following the success of our inaugural 2025 edition, we invite leading intellectual property professionals across the Caribbean to be part of the second edition of the Caribbean IP Annual 2026 and share their specialized knowledge. Be featured in the Caribbean IP Annual 2026. Reach out today at www.caribbeanipannual.com or email cipannual@northonsprmarketing.com or call +44 02 03 813 0457. Advert 2. 2026 IP Owners Spring Summit. March 18th and 19th, 2026. Westin Hotel, Washington, D.C. 2026 IPO Annual Meeting. Save the date. September 27th to 29th, 2026. Sheraton Hotel, Toronto, Canada. For more information, visit www.ipo.org.
Page 51. Inside back cover advertisement. Northons Media PR and Marketing Ltd. Specialists in intellectual property publishing, media, PR, and marketing. Professional services for the IP industry. Publishing. Social media management. Brand awareness/lead generation. Event planning and management. Website development and maintenance. Contact us today for free consultation. info@northonsprmarketing.com. Telephone +44 0203 813 0457. www.northonsprmarketing.com.
Outside back cover advertisement. Final page. Pat World. Global IP research services and training. Pat World resurrects services. Trusted, reliable, accurate. The Pat World team combines scientific expertise with commercial insights to deliver comprehensive IP research solutions. Our services: Partner with a team trusted by tech companies, universities, and IP professionals worldwide. Freedom to operate searches, patentability assessments, validity analysis, competitor and technology tracking. Coming soon, CPD Certified Introduction to Patent Searching online course, relaunched in October 2025. Get in touch. Phone +44 0 163 381 6601. Email mail@patworld.com. www.patworld.com. Innovation House, 6 Cedar Court, Celtic Springs, Newport NP10 8FY.
You have been listening to issue 24 of the Global IP magazine. If you would like to be part of the industry's #1 IP publication to share your knowledge with the global IP community, then please reach out to us at telephone +44 0203 813 0457 or email us at gip.magazine@northansprmarketing.com. Visit our website www.globalipmagazine.com. Thank you.